hatred could be broken and that he could make amends, ending with, "I'm sorry once again for stealing the joy from your lives." Cole Cannon's daughter was unimpressed by Evan's statement at his resentencing, calling it self-serving. Throughout the prolonged ordeal, she was vocal in sharing how resentencings such as these re-traumatize and re-victimize the survivors. She said of Evan, quote, "I don't think he admitted guilt. I think it's insincere. I think it's too late. You can say words and not mean them, and that's exactly what he did."
He committed a heinous act. He is unremorseful to this day, and it's almost 9 years later. It was very heinous, and when you have sociopathic tendencies and you're not remorseful for your crime, then he doesn't deserve to be out.
Evan Miller remains serving life without parole at St. Clair Correctional Facility in Springville, Alabama, and will be 32 years old this year. Though eligible for parole already, accomplice Colby Smith remains incarcerated at Staten Correctional Center in Elmore, Alabama. When making their determination in 2012, the Supreme Court did leave room for life without parole to be used on juveniles, but only in the rarest of instances. The justices were aware that the rare juvenile offender who exhibits such irretrievable depravity that rehabilitation is impossible and life without parole is justified may exist, however, stressed that imposing it should be an extraordinary circumstance. Specific factors for such a term, now commonly referred to as the Miller factors, were developed, which require the following to be evaluated before life without parole can be sentenced: the child's age and maturity level, their family home environment, their role in the offense, any disadvantages in dealing with the justice system, and their potential for rehabilitation.
Fear over the super predator led to a tremendous number of laws and policies that we're just now recovering from.
As always, thanks for listening. Be back soon with another episode, but until then, lovelies, don't be scared.
In case number 10-9646, Miller v. Alabama, and the related case, 10-9647, Jackson v. Hobbs, Justice Kagan has the opinion.
In each of these two cases, a 14-year-old was convicted of murder. Petitioner Kuntrell Jackson was convicted on a felony murder theory. He accompanied two other boys to a video store to commit a robbery, and one of those boys shot the store clerk. Petitioner Evan Miller was convicted of murder in the course of arson. He and a friend beat Miller's neighbor with a bat and then set fire to his trailer after an evening of drinking and drug use with the victim. Both boys were sentenced to life imprisonment without any possibility of parole under statutes that made that sentence mandatory. We hold today that mandatory sentences of life without the possibility of parole for juveniles violate the Eighth Amendment's prohibition of cruel and unusual punishment. That clause of the Eighth Amendment guarantees individuals the right to be free from excessive sanctions. And that right flows from what we have called a basic precept of justice, that punishment for crime should be graduated and proportioned to both the offender and the offense. Two strands of precedent applying this principle lead to our holding today. The first line of cases has emphasized children's lesser culpability and greater capacity for change in holding that certain sentences may not constitutionally be imposed on them. In Roper v. Simmons, we held that the Eighth Amendment bars capital punishment for juveniles, and in Graham v. Florida, we concluded that the amendment also prohibits a sentence of life without parole for a juvenile convicted of a non-homicide offense. Those cases demonstrate that the differences between children and adults diminish the justifications for imposing the harshest sentences on juveniles, even when they commit truly terrible crimes. And most fundamentally, those cases make clear that youth matters in determining the appropriateness of certain penalties, that imposition of a state's most severe penalties on juvenile offenders cannot proceed as though they were not children. Our decision in Graham also likened life without parole for juveniles to the death penalty itself, thus evoking a second line of our cases. In those decisions, we have required sentencing authorities to consider the characteristics of the defendant and the details of his offense before imposing the death penalty. Those cases, too, repeatedly emphasize the importance of considering the mitigating qualities of youth, immaturity, impulsiveness, failure to appreciate risks and consequences, sometimes terrible yet inescapable family circumstances, and the way all of those factors may relate to the nature of the particular crime. Here, the confluence of these two lines of precedent leads to the conclusion that mandatory life without parole for juveniles violates the Eighth Amendment. The states contend that because 29 jurisdictions make life without parole mandatory for some juveniles convicted of murder, the practice must be constitutional. We disagree. Although we look to such numbers in considering categorical bars to a punishment, in this case we do not erect such a bar. We do not ban life without parole for juveniles. We only require that a sentencer consider all relevant circumstances before imposing it. In similar situations, this Court has not counted laws in the way the states here propose. Further, the number of states that impose mandatory life without parole is actually lower than the number we considered in Graham allowing life without parole for non-homicide crimes. There, 39 jurisdictions authorized the sentence that we held unconstitutional. We explained in Graham, and the explanation holds just as true here, that simply tallying the number of states that impose such a sentence on children presents a distorted view. Most jurisdictions have never passed a law specifically addressing juvenile life without parole. Instead, those sentences result from two separate provisions passed at separate times. One that simply allows juveniles to be transferred to adult court, and another that imposes life without parole on anyone convicted there. So we cannot conclude that any given legislature has endorsed this penalty. A mandatory sentence of life without possibility of parole for juveniles precludes a sentencer from taking account of an offender's age and the wealth of characteristics and circumstances attendant to it. Under those schemes, every juvenile receives the same sentence as every other. The 17-year-old and the 14-year-old, and for that matter, the 10-year-old, the shooter and the accomplice, the child from a stable household and the child from a chaotic and abusive one. And each juvenile, including these two 14-year-olds, receives the same sentence as the vast majority of adults committing identical homicide offenses. Preventing judges and juries in that way from thinking about all of the differences between children and adults and among particular children violates the Eighth Amendment. The judgment in both cases is reversed and remanded. Justice Breyer has filed a concurring opinion in which Justice Sotomayor joins. The Chief Justice has filed a dissenting opinion in which Justices Scalia, Thomas, and Alito join. Justice Thomas has filed a dissenting opinion in which Justice Scalia joins. Justice Alito has filed a dissenting opinion in which Justice Scalia joins.